As promised, ladies and gentlemen, this morning we are going to be discussing how does a grand jury work. You know, everyone is talking about the Eric Garner case. Everyone is talking about what they expected and, you know, what should have happened. But, you know, in times like these, we have to get the legal minds. We have to get the bright legal minds to talk about situations like these. And a lot of folks don't understand, Breadman, how does a grand jury work? And I don't know if you yourself understands how it works.
I'm not going to say I know fully. There's always more for me to learn.
So this morning we're joined by attorney JOAN from the law firm of Drummond and Scalacci. Ladies and gentlemen, so let me go directly to the telephone line and say good morning to Ms. Scalacci. How you doing this morning, JOAN?
Good morning, Rasclon. Good morning, Breadman. And I want to first take the opportunity to thank you for having me this morning and wish you and your listeners a happy belated Thanksgiving and a happy holiday season.
Thanks very much to you and your family too, Ms. Scalacci. And Breadman,
thank you.
I understand that also we're joined by a retired police officer.
Yes.
Is that correct?
Yes.
Okay, but before we go to the police officer, the retired police officer, Ms. Scalacci, explain to the community, explain to my listeners, how does a grand jury work?
Yes. In New York, for a grand jury, and it's also nationwide, obviously state-by-state procedures may be a little different. But in order to prosecute someone for a felony offense, which are the higher level offenses in the penal law, you have to get what's called an indictment. And there's a cliche out there that you can indict a ham sandwich, and that if a prosecutor really wants an indictment, they're easy to get. And the reason why that is the understanding is because it is the lowest burden of proof in the criminal system. It's not the same as trial, which is beyond a reasonable doubt, where all jurors have to agree. This is the lowest standard. It's literally, does the prosecutor have probable cause? It's like a more than 50%. And what the grand jury indictment does, it's not a trial. It's a procedure where the prosecutor presents witnesses to testify, sometimes physical evidence. They panel the grand jurors. They present the evidence, and they decide what charges to present the grand jurors, whether or not to indict. Now, they decide, they control. There's no judge that controls the proceeding like a trial. And in essence, it's whether the grand jurors, to kind of describe it in layman's terms, will give the district attorney's office the green light to go forward with a case and bring a case to trial. And there's a lot between indictment and trial. Or do they give them the red light? No, you don't have probable cause. Go forward with this case on these charges that you present to us. And a prosecutor is charged with the obligation to present charges to the grand jury based upon the facts of the case. What charges under the penal law do the facts of a particular case fit into? And so when you have this proceeding, there's no judge involved. There's no cross-examination of the witnesses that are there, and that is how the grand jury process works here.
Okay, so
and
there
it is...
Sorry. So in this situation, there's no defense to present their case.
Well, there is, and this is what is troubling about this case. A grand jury proceeding can happen twofold. Someone can get arrested by police and be brought for an arraignment on a criminal court complaint, which gives them an outline of what the charges are against them. And if those charges include felony charges and the prosecutor wants to seek the indictment, then they have to commence the grand jury proceeding, and they're obligated to notify the person who's been arrested, the defendant, of when that proceeding is going to happen, and they can exercise their right to testify. In a grand jury proceeding, when the defendant testifies, they can have their lawyer present, but a lawyer can't make objections like a trial. And again, the lawyer can't cross-examine the witnesses. The other way a grand jury proceeding and an indictment can occur is unbeknownst to the suspect, the future potential defendant. A grand jury panel is paneled, and a grand jury proceeding is done, and there's an indictment, and then the person gets arrested on the indictment. In this case, neither of those things happened. Officer Pantaleo was not arrested and arraigned on a criminal court complaint, and then this grand jury proceeding happened. And he was allowed to testify in the grand jury proceeding without having been arrested first with a criminal court complaint. And it wasn't done unbeknownst to him, and he was now arrested on a potential indictment. So he was allowed to testify, and this is why if there's a federal inquiry, which I believe the government indicated there is going to be, and they're steering an investigation for civil rights violation, they really need to steer a separate independent investigation into D.A. Donovan's presentment, because to allow someone who's not yet a defendant to testify in the grand jury steers it towards a certain outcome. And then there's the question of the charges that D.A. Donovan presented to the jurors to charge or not charge. And that's a huge issue that should be investigated.
Right. And you know, some people are talking that, you know, these charges probably were overcharged, and, you know, and that's why, again, now, before we join Chuck, let's bring Chuck in on this conversation. But before we bring Chuck on the air, Ms. Kalachi, when you look at the evidence that was presented here, when you look at what happened to Eric Gardner, you know, I was saying to Breadman earlier on, we were discussing what is resisting arrest, because we were saying amongst ourselves that we did not see Eric Gardner resisting arrest. But funny it is, I had a conversation with you yesterday, and you mentioned something to me about verbally resisting arrest. Explain what that means.
Yes. Let me first say that the whole situation really is a tragedy. Obviously, Mr. Garner's death is a tremendous tragedy that really should never have happened and could have been avoided. But there's also another tragedy. Not all police officers are bad. And the ones that go outside the law, commit crimes, go outside their professional responsibility and commit acts and offenses against others should be held accountable, but we shouldn't blanket all police officers because of a few bad ones, just like any profession. And that is another tragedy. My father was law enforcement, so I have great respect for those police officers, firefighters who literally signed up for a job and volunteered for a job to run to danger every day. But those who go beyond that and commit crimes or commit offenses should be held accountable. So at the same time, you know, there's talks of peaceful protests, and I'm happy that in New York there's been peaceful demonstrations, because you can't blanket the whole profession for a few that should be held accountable for the wrong actions that they do.
This is true.
And resisting arrest is a crime, and you heard the PBA delegate talk about resisting arrest is a crime. Resisting arrest it depends on what is the resistance. You can verbally resist arrest. If an officer tells you to put your hands behind your back and you don't, and you say no, that is resisting arrest. And if an officer tries to arrest you or put cuffs on you and you run away and you ensue flight, that can be considered resisting arrest. And I think the police department, amongst all the other things that there needs to be some retraining and new training on, when you talk about the use of force to detain someone because you're trying to effectuate an arrest, the use of force has to be measurable and proportionate to what is the level of resistance. And to use force, and now it is clear that the use of a chokehold is
force.
Not allowed by the internal New York City Police Department regulations in their guide for use of force. So if Mr. Garner is verbally resisting by saying no, then why is there not just a physical use of force, but such a level, obviously, of a physical use of force? And I think it goes back to when this case first came into the media, and the media publicizes he's been arrested 30 times, sometimes in an effort to justify what happened. It's never a justification.
Well,
but the important question is not how many times he's been arrested. How many times has he been convicted? He's never been convicted.
Of anything.
And so when you have 30 arrests and he's never been convicted, you can understand Mr. Garner's state of mind to say, listen, no more. Leave me alone. And does that contribute to whatever level of resistance there may be? But the video is clear. When he does have his hands up at a certain point, and what's completely clear is when he consistently and repeatedly is telling the officers, I cannot breathe.
11 times.
And
11 times.
Yes, 11 times. And this is why it goes back to what D.A. Donovan charged the grand jury. There's information, while certain information is being released and other information from the grand jury is not. And the grand jury proceedings are sealed. And they're meant to be that way. He did not charge reckless endangerment. And there's a felony level reckless endangerment, and there's a misdemeanor level reckless endangerment. And separate and apart from any other charges, I think based upon the video alone, and Mr. Garner indicating 11 times that he cannot breathe, I am confident that a jury would, in grand jury proceeding, listening to the evidence and seeing the video, had they been charged
Right.
with reckless endangerment, I believe an indictment would have and should have come down.
Bread man, make myself your lively, is not a dead man.